You were part of Ken Starr's independent counsel team, which conducted a sweeping investigation into possible wrongdoing by President Clinton and the First Lady. At the time, you argued for aggressive questioning of the president. You did not take the position that President Clinton was immune from investigation. Since then, you have taken the opposite position. In fact, you have said that, and I quote, "If the president were the sole subject of a criminal investigation, I would say no one should be investigating that at all." What did you mean by that? And what are the circumstances where a sitting president could be subject to criminal investigation?
And I appreciate the sign there. Senator, the last sign I should have mentioned while it was up, the Second Amendment sign actually had a brackets around part of my quote, and I'm not sure if it was the exact quote, but this one, I just wanted to point that out.
Is this accurate?
Here's what I was saying, Senator. Let me explain it. This one. The last one may or may not have been accurate. I just wanted to point that out for the record. It had brackets for my quote. This one. So what happens after the Starr investigation? Then I worked 5.5 years in the White House. So let me just give you, if I can, some context here, and I'm going to get specifically to your question. So I work in the independent counsel investigation, and that is obviously difficult, controversial, a moment for our country that I wish hadn't happened. We all wish it hadn't happened. And I reflect on that. I wrote a Georgetown University Law Journal article in '99 reflecting on some of my thoughts about that. This seems to be a tendency of mine to go through an experience, write an article reflecting on it. And then I work in the Bush White House for 5.5 years. And I write an article in the Minnesota Law Review, Senator Klobuchar, in 2009, when President Obama is in office, I should point out. And I reflected on a number of things I had learned working in the independent counsel office and then working in the White House. And I thought there were a number of things Congress could take a look at that I had experienced. One of them was I proposed timelines for consideration of judicial nominees. I proposed a 180-day up or down vote for every judicial nominee. That was something that, from my experience, I thought would avoid controversy and have rules of the road set in advance, and I proposed that specifically for Congress to consider. Other aspects, I said, another thing I proposed was for Congress to consider whether it should look at Clinton versus Jones or the principle of Clinton versus Jones. So you call Clinton versus Jones and said a president is subject to civil suit while in office, the Paula Jones suit. That was a controversial decision, but the Supreme Court made clear at the end of the decision Congress could provide extra deferral of suits, not immunity, but deferral of suits for presidents if Congress so wanted. And so in the Minnesota Law Review article, I put out some ideas about whether Congress may want to think about that. And why did I do that? I think Senator Durbin asked yesterday, what changed that made me think about that from the time? What changed was September 11th. That's what changed. So after September 11th, I thought very deeply about the presidency. And I thought very deeply about the independent counsel experience. And I thought very deeply about how those things interacted. And I thought very deeply about seeing President Bush. When he came into the Oval Office on September 12, 2001 in the morning, President Bush said, "This will not happen again. This will not happen again." And he was of single-minded focus. Every morning for the next 7 years for President Bush was still September 12, 2001. Single-minded focus. And then thinking back to the independent counsel experience in August of 1998. So I proposed some ideas for Congress to consider. Here's the bottom line point. There were ideas for Congress to consider. They were not my constitutional views. If a case came up where someone was trying to say this is a constitutional principle, I would have a completely open mind on that, because I've never taken a position on the Constitution on that question. I've only put out proposals for you all to study, to think about the balance of a president fighting a war, leading a war, and a president subject to, say, ordinary civil lawsuits as in the Clinton versus
Let
Jones
me ask
case.
you